On behalf of Jones Day, we'd like to welcome you to the Introduction to the GDPR Top 10 Implementation Issues for Companies. This program is scheduled to run from noon to 1:30 p.m. Eastern Time. If you're having difficulty hearing me, please check to make sure that you have volume on your computer turned up all the way. If you have any other technical difficulties, please contact the Beacon Live Help Desk at 1-877-297-2901. Also, if you've not already downloaded a copy of the presentation materials for the CLE Credit Information Sheet, you may do so from the Handouts tab on the left. This presentation has been approved for CLE credit for attendees. The CLE Credit Information Sheet provides you with information regarding the available credit. Applications for CLE credit in other states will be made as needed. Please keep in mind that CLE credit is not available when viewing the on-demand version of the webinar. There are several important steps that you must take to demonstrate that you are actively participating. First, each participant must have registered individually for the webinar in order for your time of attendance to be recorded. If you have not individually registered for this webinar, please do so immediately by contacting Wendy Sung at wendysung@jonesday.com. Second, at various points during the webinar, a box will pop up on your screen asking you to confirm that you are viewing the webinar. You have up to 1 minute to confirm your participation. If you do not confirm each time the box appears, you will be denied CLE credit. Third, you must be logged in for the entire presentation or segment. Otherwise, CLE credit will be denied for that segment. Within 24 hours, you will receive a link to generate your CLE certificate. If you do not receive the email, please contact the Beacon Live Help Desk or email cesupport@beaconlive.com. It is mandatory that you enter your bar number. If you cannot locate your bar number, please contact the Beacon Live Help Desk for assistance. You will be in listen-only mode throughout the presentation. If at any time you have a question, you may submit them through the chat window located in the lower left corner of your screen. We will attempt to answer those questions at the end of the webinar. Now, with the housekeeping items out of the way, I would now like to turn it over to our speakers for the live presentation.
Thank you very much. I'm Undine von Diemer from Munich, Germany, and I would like to welcome you to the first part of our webinar series on the EU General Data Protection Regulation, the GDPR. I'm very pleased to be joined by my other European colleagues, Paloma Bru from Madrid, Laurent de Moite from Brussels, Olivier Haas from Paris, Jörg Ladig also from Brussels, Jonathan Little and Liz Robertson from London, and Giuseppe Mezzapesa from Milan. We do not want to be theoretical today and tell you that the GDPR is actually the most important piece of data protection legislation that the EU has ever seen. Although this is correct, we really want to be practical and go straight to the point, focusing on the top 10 implementation issues for companies. Based upon our experience from advising on various GDPR implementation projects, we selected the following topics for today's presentation. We will talk about privacy policies and consents, also about how to handle the new and extended rights as a data subjects. Creating records of data processing activities will be another important topic, similar to data protection impact assessments and privacy by design approach. The appointment of a data protection officer and the new requirements for data processing agreements with providers will also be topics. Last but not least, we will cover the need to implement a data breach notification and response plan, as well as ensuring compliance with cross-border data transfer requirements. At the end of the presentation, we have reserved time, around 15 minutes, for a Q&A session, during which we are very happy to answer any of your questions, and therefore we encourage you to use the Q&A tool in the webinar program. And now I turn it over for the first part of the presentation to my colleague Jörg Ladek from Brussels.
Yeah, thank you very much, Undina, for the kind introduction. Let's look at the first topic that Undina announced today in that long list of presentations that you will receive. We will talk about what does the GDPR require in terms of providing transparent information to individuals. So that has to do with preparing or updating, reviewing data protection notices, policies that you're currently using in the organization. So we have listed on the slide here, as you can see, what the data controller, the entity that's responsible for compliance, so to speak, has to provide in terms of information. And this is a very long list. It's similar to what we have been seeing in the directive so far, and the information has been implemented in a different member states' law. But the GDPR has basically now extended that list. So I would like to just run you quickly through this list and maybe emphasize on a couple of these items which are new and to which you should pay attention to. So companies now are asked to provide information about the identity of the data controller and the contact details, which is not really something that's changing when we compare GDPR. But what's new is that you also have to inform about who is your actual data protection officer in the organization. Further, companies have to basically inform about the purposes of the data processing and what's new, the legal basis that you rely on in order to process the information. So that's a new development that we haven't seen in the directive so far or any national member state law. You further have to, in more detail, be very specific. If you base your data processing on legitimate interests as an exemption, as a legal basis, then you have to explain these legitimate interests in your privacy notice or policy. You further have to inform about the recipients or categories of recipients, which is not really something new here. What is new is the international data transfer requirement. You have to here, again, be very specific and inform individuals in your notices, policy documents about the exact data transfer mechanism that you have chosen in order to transfer data internationally. We will talk about this later during this webinar. What is new also is the requirement of the GDPR to inform individuals about data retention periods, which based on our experience and practice can be quite challenging because you would have to identify how long do you keep certain data and information of individuals in the organization. And you have to be very clear about that, otherwise you're not able to put that information in your policy or notice. You also have to inform about the rights of the individuals, including the right to complain to the Data Protection Authority. That's something new, so you really have to indicate now that this right exists in addition to the other rights that we will explain further in the webinar that individuals have under GDPR. Last but not least, I want to mention that also companies have now the obligation to inform about any kind of automated decision making, including profiling. So any kind of data processing activities, and we're talking about big data activities or similar activities that include perhaps profiling, you would also have to basically inform individuals about that kind of activity. Another element that I want to point out when we look at the GDPR requirements, and again, this is almost 2 pages in the legal document. It's a very long list of obligations. Is the change of a purpose. So the moment you and your organization are looking at certain data processing activities, and you're thinking about using certain data for another purpose for which the data was originally collected for, the GDPR tells you that you now have to inform individuals basically upfront in the notices and policies that you intend to use the data for other purposes. And you have to provide information about that other purpose that may not be clear at the beginning of the data processing. So that, again, is something that we see companies struggling with in terms of providing transparent information to individuals. There are additional requirements that apply when you retrieve certain data from other sources. So when you do not collect data directly from the individual, then the GDPR also sets out additional requirements. So the GDPR, in addition to just telling you the different requirements, what you have to inform about, also gives clear guidance and instructions on how this information should be provided. Remember that the cornerstone of the GDPR is to provide transparency to individual users and, for example, employees, customers, consumers, in terms of not only the information, but also that they can understand what's actually going on with that processing activity in the organization. So the GDPR requires that all this information should be ideally presented in a concise, transparent way. It should be using clear and plain language and can be provided also in electronic means. A new element to this is that companies now have the choice to provide the information together with, in combination with standardized icons to the extent possible. So the idea of the European Commission here, the legislator, was clearly to give companies some tools they can use in order to make long and legalese data protection notices and policies more readable, understandable for the user, in order for them to comply, in order for the individuals to better understand what's going on in terms of processing activities. So what does it mean actually in terms of to-dos? And Undine mentioned that at the beginning. We tried for each of the topics to tell you a bit practically how things, very high level of course, but gives you a first idea on how to approach things in practice. With regard to any kind of data protection notices policies you currently have in place, obviously the GDPR requirements requires you to go back and look at them, review them, and maybe update them as needed to make sure all these different items are mentioned in these texts. And you also have the possibility, as I mentioned, to basically use icons that indicate certain data processing activities. There's no clear guidance yet out there by the data protection authorities, but that's something that we will see will be coming and developed in the future. Last but not least, I think we also see a number of different companies choosing different approaches how to inform individuals of the processing of data that concerns them. Why? Because obviously your communication and information channels may be very different between your customers and employees, for example, on the other side. So that's something strategically that we see companies more and more consider. So that's another recommendation to look out for. And with that, I hand over to our next speaker today, which is my colleague Paloma. Thank you.
Thank you very much, Jörg. The second topic to cover is related to the role consent in GDPR. The consent is one of the legal bases established in the GDPR for processing of personal data. However, we cannot use the consent as an absolute base applicable in all cases. If the consent is not applicable, we will need to find another alternative legal basis. Then the first question that we need to do is, when can we use the consent as a valid legal basis? The GDPR is clear in this point. Only in the cases in which the data subject has a real choice to decide if data controller or maybe a third party can process or not their personal data. Then the consent is not valid when there is a relationship in which there is a clear imbalance between the data subject and the controller. For example, this is the case of a labor relationship or a relationship between the public authorities and data subject. Or in cases in which the controller would still process the personal data based on a different legal basis if consent is revoked by the data subject. It will be the case, for example, when the processing is necessary for the provision of a service. When we confirm the consent is the most adequate legal base, the second point that we need to analyze is what are the requirements that we need to comply in order to obtain a valid consent for processing personal data under the GDPR. In this regard, the GDPR maintains the key element in the standard consent definition. The standard consent definition for processing of personal data should be free, specific, informed, and must indicate the agreement of the data subject with the processing. However, the GDPR has established new and additional requirements to obtain a valid consent. These new requirements means, from a practical point of view, that now it's necessary that the consent be an ambiguous indication or a clear affirmative action of the data subject. Then now the tacit consents are not valid under the GDPR. Silence, per-ticket boxes, inactivities cannot use as a valid way to obtain a valid consent. Secondly, the consent must be unbundled. This means that the consent requests need to be concise, separate from other terms and conditions, and in a clear language that permits to explain the data subject how the data will be processed. Also, the consent must be granular. That means that it's necessary to obtain the consent for all the different type of processing or purpose. For example, it's not valid a general statement for several processing or purpose unless these processing are directly or clearly related. Third, the consent must be easily to revoke by the data subject at any time. The data subject needs to know from the beginning that they have the right to revoke their consent at any time and how to do this. From the practical point of view, this implies that it's necessary to have implement in the company procedures to receive the revocation of the consent. In all cases, it's essential that we documented the consent obtained and maintain records to demonstrate that we have consents when and the scope of these consents. The standard consent described is not sufficient for processing some personal data or some processing. The GDPR has established additional requirements for the consent used to process sensitive data, children data in some specific cases, and science research data. To process sensitive data, it's mandatory to obtain an explicit consent. The key difference of the explicit consent and standard consent is that explicit consent must be affirmed in a clear statement. It may be written statement or oral statement, and must expressly refer to a specific processing. Also, should be requested in a separate manner for any other consent that we want to obtain. This approach to the meaning of the explicit consent has been confirmed by several DPAs, such as the UK, Spanish, and Bavarian DPAs, in their guidelines about the GDPR. The second case in which the GDPR has established additional requirements to obtain a valid consent is when it's necessary to obtain the children's consent to receive information society services. In this case, the controller must obtain the parental consent for children under 16. This age can be reduced by the local legislation, but no more for 13 years. To comply this requirement, from the practical point of view, the controller must implement a age verification measure. Finally, regarding the consent for processing personal data for science research, under the GDPR, it's necessary to ensure that the data subject has the option to consent only several areas of the research or parts of the project. It's not valid a general consent for science research. I would like to stress that processing personal data based on invalid or inappropriate or not adequate consent can generate for the company the maximum fines established in the GDPR, and also can generate a claim against the company from the data subject for the damage caused. And of course, can imply a strong damage in the reputation of the company. To finalize this section related to the consent, in terms of the necessary measure to ensure that our company comply with the GDPR requirements, the first step is to identify all the processing carried out by the company or the group of the company, to check and choose the most adequate legal basis for each of the processing carried out in the framework of the activity of the company. When we have this information, if the consent is the applicable legal basis, it will be necessary to ensure that all the consents meet the GDPR requirements in terms of scope, content, and the way used to obtain the consents. And also, it will be necessary to verify that we have documented all the consent obtained. If the current consents do not comply with the GDPR requirements or they are not documented, we need to obtain the consents again. From the internal procedure point of view, it's very important to implement adequate procedures to guarantee the right of the data subject to revoke the consents at any time. Also, if the controller uses the service of a data processor to management their consents, it will be necessary to review the provision related to this engagement included in the data processing agreement to adapt them to the GDPR requirement. It's necessary to take in mind that the measure to comply with the consent requirements are not a static measure, and it's necessary to update and review regularly to check if the consent keeps going to the most adequate legal basis. Now my colleague Laurent is going to continue with the next item related to the rights of individuals. Laurent, please.
Thank you, Paloma, and hello to everyone. I wish you a good lunch if you have time to grab a sandwich while listening to this presentation. And so we're going to speak about the right of individual. Who are those individuals? Those are the natural person, which are your employees, customers, suppliers. And under the GDPR, the right of those individuals have been even extended, and there have been even new rights that have been added to the list. And so you see the list on the slides. And if you start with the right to access the data, that is an example of a right that has been really extended. So it means that an individual has a right to get a copy, so it's not already you really need a written copy, and it can require such a copy of the data at reasonable interval. You need to respond quickly. You have typically a month to respond to any request. You need to provide that on a free basis, so you can only charge if there's more than one copy required, and even then you need the charge needs to be based on cost. If possible, that access needs to be given via direct remote means and secured system, so you need to have an online system to the extent that's possible. Of course, if in the context of big data, if you handle a lot of data, there is a right, of course, to go down, to go back to the data subject, to the individual, and ask them to tailor down their request and to make sure that you provide the data to the processing they really refer to. That right also includes the right to provide additional information, just as merely providing the existence of a processing of data. So even if you're not processing data, or you're processing data but not of that particular individual, you have an obligation to respond and to communicate that you're not processing that data. Other type of information that you need to give includes information such as the purpose of the processing, the retention time, the logic and the consequence of profiling, and so on. Another right that it has been given is the right to rectification. So that's basically the right to rectify any mistake in the data. It also includes the right to add additional data to include that for the controller. The third right is the so-called right to be forgotten. So in some case, the individual can ask for the data to be deleted. That is actually a right that has been recognized by the Court of Justice for search engine, the Google Spain. It has been recently extended, but for very limited extent for company registered as well. And so under the GDPR, it applies in certain conditions, such as when the data is no longer necessary, where the data subject withdraw its consent or exercise its right to object, when the processing is unlawful, when you want to comply with a legal obligation, and also when the data is collected from a child. There are some exceptions to that right, which includes the freedom of expression and information, when there's a legal obligation, a public interest, or in the case of defense of and legal claims. The fourth right is the right to restrict processing. That basically will only occur if there is a litigation ongoing about the data, and that right basically amounts to right to lock the data. So you can only store the data and can not do anything else with the data. Then you have the right to data portability. We'll move on to that one. That is a real new right under the GDPR, and that's the only right for which we already get some guidelines from the Article 29 Working Party, as it is still now called. So there we already have some guidelines. We'll speak about it in a minute. Then you have the right to object to the processing. So in some case, like there in marketing or legitimate interest, you can refuse the processing. And finally, there's a general prohibition on profiling, or more generally, the right not to be subject to automated decision-making which produce legal effects. What does that mean? I mean, this includes profiling, that is when you, for example, behavioral advertising, it's publicity based on geolocalization and so on, and generally a decision which is based on which produces effects is case like if you have a loan which is given only based on an online form, or recruitment that's purely online, that is not possible under the GDPR. Again, there the principle is a general prohibition, but you have some exception, such as when you have to conclude or perform a contract, when it's authorized by law, where you have the explicit consent of the individual. Even in that case, I mean, the data subject needs to be able to interact with a human person, and it needs to be able to contest any decision that is based on this automated processing. So if now move to and focus on the new rights to data portability, I mean, that is a right that is also a lot to do with competition and facilitating churn of consumer. The idea was really to eliminate barriers to switching for customers, for example, in the area of social network. I mean, it's an idea that comes from the telecom sector and the mobile number portability obligation, and it's the idea that you can transfer the data from one controller to another controller. What's important to note is that this is a right that only applies in certain circumstances. So it only applies if the treatment is based on consent or on a contract, and it's carried out by automated means. What's also important to note is that it only applies to the data that have been provided by the individual to the controller. So it does not apply to data that has been created by the controller on the basis of the data that were submitted by the data subject. And so it boils down to two rights. It's the right, first, for the data subject to obtain in a structured, commonly used and machine-readable format the data, and then to transfer it to the new controller. But it also includes a right to ask for the former controller, when it's technically possible, to transfer directly the data to the new So that raises, of course, questions and opportunities for standardization to have this kind of direct transfer of data between controllers. So if we move to the to-dos based on those rights, I mean, as for previously, you need clearly to review all your notice and make sure to adjust to those rights. You need to review your internal process and procedures to make sure you can handle any requests by individuals, because you need to respond within a specific time. You need to be able to show that you have respected those rights. You also need to adapt the contract with third party. I'll come back to that. But of course, if you use a contractor, you need to make sure that they also comply with and make sure that you can abide to your obligation. It also includes a technical aspect. You need to review your IT system to make sure that you can handle the requests of the data subject. And finally, and that's more in relation to data portability, I mean, that is a right, as I'm saying, as I told you, that has also to do with the with creating opportunities and of switching customers. So that is something you may wish to assess, is the opportunities in particular is as new entrant in some markets to obtain data from third parties and incumbents under the condition for data portability. So that's in a nutshell about the individual right, and now I hand over to Undine.
Thank you very much, Laurent. So creating records of processing activities, that's probably from an operational point of view the most challenging task, and it's a starting point and at the heart of every successful GDPR implementation project. The GDPR says that a controller is obliged to maintain a record of processing activities which contains certain prescribed information. So a controller is the entity that determines the purposes and the means of processing. So the entity that really has a say what to happen with the data. For example, the employer is a controller in terms of the personal data of its employees. The processing activities that are referred to are not IT applications, like for example Workday or Outlook. Processing activities are really the activities pursued, like for example payroll processing, and those activities need to reach a certain level of detail. For example, simply saying HR processing would probably be too broad in this regard. The records of processing activities shall contain the name and the contact details of the controller and also mention the data protection officer. The management, the directors for example, do not have to be listed. They can be listed, however. Purposes of processing are, for example, payroll processing or timekeeping, if we come back to the area of HR data processing. Categories of data subjects are, for example, employees or applicants, and the categories of personal data, depending on the relevant processing activity, coming back to the example of payroll processing, can be master data of employees like name and physical address, financial data, like for example the bank account details or tax information. Categories of recipients need to be listed too. Again, coming back to the example of payroll processing, those categories of recipients can be banks or the Social Security Agency or providers that you are using for this purpose. Transfers to third countries, this means transfers out of the EU, need to be specifically mentioned. Also, the time limits for erasure need to be mentioned. This is, for example, the applicable data retention obligations under tax and commercial law. Finally, the technical and organizational security measures that the GDPR requires for the relevant processing activity need to be included. It can be that a company applies the same high level of IT security for all of its processing activities. In such a case, the description of the technical and organizational measures would actually be the same for each processing activity. Not only controllers, but also processors are obliged under the GDPR to maintain a record of processing activities. It's, however, a bit shorter for the processors, so they have to mention not only their name and their contact details, but also the name and the contact details of each controller on behalf of which they are processing. For example, in case of a cloud provider, this would mean a customer list, more or less. Also, the data protection officer would need to be included. The categories of processing carried out on behalf of each controller need to be included. Coming back to the example of payroll processing, this would be a category of processing. Similar to controllers, the processors need to mention any transfers to third countries and have to include a description of the technical and organizational security measures that they are taking in regard of the processing activity. So how, from a practical point of view, approach this task? I guess the first step would be to verify the existing data mapping information. For example, in Germany, under the currently applicable law, there is already an obligation existing to maintain a so-called register of proceeding, which should include almost the same information as is required under the GDPR. So starting maybe with your German subsidiary and look what is there might be a good idea. It then should also be decided whether any kind of additional information shall be collected in the records. It's, for example, possible to include data classification information. It's important to select a tool to assist you with this task. In a smaller company, a simple Excel file following the requirements of the GDPR might be sufficient, but for bigger companies that have to maintain hundreds or even thousands of records, an online-based tool or a cloud-based solution might be more suitable. From a practical point of view, it might be advisable, especially in matrix organizations, to start with preparing the records on a department level and not on an entity level. For example, asking HR first to draft the records, looking at their relevant processes, and then verify on the entity level whether the description is also correct from their point of view. It's practically important to appoint a process owner for each record, because this will help you to ensure that the records stay current and correct, as this is an ongoing task. The records can be in English if the company language is in English, but they would need to be translated upon request of the DPA. In this regard, it's important to keep in mind that the records are not public, but that the DPA can request to be provided with the records in the respective language. So you must be prepared to provide for translations. Finally, guidance of the Article 29 Working Party on how to set up records of data processing is still to be expected in this year, and will hopefully also contain templates for this purpose. Now I turn it over to my colleague Giuseppe Mezzapesa.
Many thanks, Undine. We are going to check what do we mean by data protection impact assessments or privacy impact assessments, if we want to use a different terminology. Those assessments are mentioned by the first time as a mandatory obligation at European level. We are talking in principle of basically a way for showing compliance with the GDPR. So this may be seen as a new tool, but in principle we can find even in the directive, at least something similar. We have seen in the directive of 1995 concepts which were maybe similar, or which implied the need of a privacy impact assessment, and I'm referring to the security of processing, which is mentioned by Article 17, but also to the prior checking, which is mentioned by Article 20 of the directive. Moreover, people from the UK may be already familiar with the privacy impact assessment because the experience in the UK is very broad, and we have seen also guidance and manuals issued by the ICO with reference to privacy impact assessment. Even in continental Europe, we have something which seems to imply a privacy impact assessment, and I'm referring to the German experience with the VORAB controle and to the verifica preliminare that we have here in Italy. What are we referring to? In principle, a privacy impact assessment or data protection impact assessment is a process aimed at identifying prospective risks which may be connected to data processing in new projects or practices. So the main difference we see with respect to an ordinary privacy audit is the fact that an audit is a retrospective analysis. Here, on the contrary, we have a prospective analysis, and the relevant data processing shall not be started until the impact assessment is being carried out. In principle, a privacy impact assessment must be conducted where data processing is likely to result in a high risk to rights and freedoms of individuals. Of course, this is a principle which is to be adapted to the specific circumstances, so the assessment must be based on the actual nature, scope, and context and purpose of the data processing. Article 35 of the regulation expressly says in which cases we have to perform the privacy impact assessment. And we are referring to the third section of Article 35. The assessment is required when there is a systematic and extensive evaluation based on automated processing, including profiling, and decisions with legal effects are based on such evaluation. The assessment is also required when there is a processing on a large scale of sensitive data or of personal data which relate to criminal conduct. An assessment will be also required when there is a systematic monitoring of a publicly accessible area on a large scale. As you may appreciate, I mean, those are very broad concepts, and Article 35 also enables the supervisory domestic authorities to issue the so-called negative and positive lists. What does this mean? The data protection authorities of each member state will issue a list of specific cases which require or do not require the privacy impact assessment. As you can imagine, this will be a very useful guidance for companies when they will have to decide if carry out a privacy impact assessment. The minimum content of a privacy impact assessment must at least include a description of the processing which is going to be carried out and the purposes of the processing. The assessment will, of course, contain a verification of the necessity and proportionality of the data processing. We will have to find in the assessment also the specific indication of the risks to rights and freedoms of the data subjects, and of course the measures that will be adopted by the company in order to mitigate the risks. Of course, if a high risk is detected, what's going to happen? Article 36 of the regulation imposes an obligation of consulting with the supervisory authority, and when the authority detects that there is a processing likely to infringe the regulation, then a written advice will be issued by the same authority. In any case, what is relevant to mention, what is worth mentioning is that the processing shall not start unless a prior consultation is completed, at least when a high risk is detected. Let's go to see what does this mean under a practical perspective. In principle, there is the crucial need of identifying data processing activities which may potentially require a privacy impact assessment. My suggestion could be to perform a soft privacy impact assessment irrespective of GDPR obligation, so that each processing activity is at least covered by, let's say, supervising by an assessment, and at least you have a clear understanding of what's going on, or which type of processing are going to carry out. Of course, data protection officers must be involved in these activities. Of course, well appointed, they should at least supervise, if not carry out personally the assessments. Another suggestion is to include privacy impact assessment in the ordinary risk management policies of the company, because this type of assessment shall become a standard instrument to be used on day-by-day activities, and this may be also helpful for the privacy by design approach. For the time being, it is important to monitor the guidance that will be provided by domestic authorities for the lists which we have mentioned, in order to obtain clarifications on which type of processing will require mandatorily a privacy impact assessment. This is it on my side. I hand over to my colleague Paloma for the privacy by design approach item.
Thank you very much, Giuseppe. Privacy by design and privacy by default are one of the main changes implemented by the GDPR. This new concept, not recognizing the privacy directive, reflects the proactive approach, proactive accountability approach followed up by the GDPR. The key point is to identify what does it mean for the company, from the practical point of view, to comply with the privacy by design and privacy by default obligation. Privacy by design implies that the company needs to take into account data protection risk from the beginning and during all the process of designing new product, service, or procedures. This means the obligation to implement in the company the appropriate measure and procedure of any nature to ensure that at any state of the activity of the company and by all the employees, the processing of personal data carried out by the company comply with the GDPR. In practice, the obligation of privacy by design constitute a new approach that means that companies will have more flexibility to determine how to comply with the security obligation, because it's the company who decide based on the criteria of state of the art, cost of the implementation, existing risks for the data subject, the type of processing carried out in the framework of the activity of the company, what are the most adequate security measures that is necessary to implement to comply with the GDPR and to ensure the rights of the data subject. But at the same time, this new approach implies the need of more resources, because to ensure an adequate compliance, it will be necessary to have more resources with adequate knowledge and to carry out prior exams. I think this is one of the main changes of the GDPR, because under Privacy Directive, the controller and the processor do not have the responsibility to decide or design the security measure that need to be implemented. They only need to apply the list of measures laid down in the different national legislation, depending on the nature of the personal data affected by the processing. In the case of privacy by default, this new concept requires that the company implement a specific measure and procedures to ensure that by default, only personal data which are necessary for its specific purpose are processed. From practical point of view, this obligation means to ensure that only minimum amount of personal data is collected, to ensure that personal data is processing for a specific purpose, to ensure that personal data is stored no longer than the necessary for the purpose collected. This quality principle is not new. However, the difference with the Privacy Directive is that the GDPR contains an explicit obligation to implement a measure to meet this requirement, and in the Privacy Directive, this obligation was a general principle. Although, as I indicated, each company should carry out its own analysis. We can identify some practical steps that may be recommendable to carry out to guarantee the compliance of the privacy by design and privacy by default obligation. For example, implement a privacy impact assessment template that the company can use each time when designs or implements a new system, product, or service. Implement a data protection policy and internal procedures related to the data retention period. Review data collection form to ensure that excessive data is not collected. Review the agreements with data processor to set out how risk and liability will be allocated between the parties in relation to the implementation of privacy by design and privacy by default requirements and obligations. And finally, apply an anonymization mechanism in the terms and with the guarantees required by the GDPR and the different criteria established by the DPAs. The GDPR has established a specific way of demonstrate the compliance of the privacy by design and privacy by default obligation through the certification established in Section 42 of the GDPR. This type of certification is voluntary, and it will be valid only for a maximum period of 3 years and must be renewed. The certification can be revoked by the certification bodies or the DPAs, the corresponding DPA, where the requirements for the certification are not longer met. It's necessary to take in mind that the certification is a way to demonstrate the compliance, but it does not reduce the responsibility of the controller or the processor. During this year, at national level, it will be defined the procedure and specific conditions to obtain this type of certification. To finalize, I would like to recall the main general measure that is recommendable to carry out in order to ensure an adequate compliance of the privacy by design and privacy by default requirements. To the extent that the privacy by design and privacy by default obligation imply an important change related on the way to approach by the company of the compliance with the security obligation, one of the key points is the training and awareness of the employees who participate in the processing of the personal data. Then, the first and more important step is to implement internal training sessions for all the employees. Also, it's essential to allocate internal responsibility for the compliance and set a budget for data protection compliance. And of course, ensure support from the senior management and for all the employees of the company. It's important to take in mind that now these issues are not only issues for the legal or system department. These are issues and obligations that needs the collaboration of all the company. The third step can be implement a privacy impact assessment template that the company can use at regular level. And of course, it's necessary to update existing procedure or implement new procedure to adapt the internal activity of the company to this new approach of compliance. So from my side, now my colleague Liz Robertson is going to discuss the next item related to the figure of data protection officer. Liz?
Thank you, Paloma. And again, many thanks to all of you who've joined in this webinar. In terms of the data protection officer, I think it's probably one of the most complex and most exciting roles within a corporate organization. The specifics of the job description given in the GDPR, Article 37.6 says that the data protection officer shall be expert in all data protection laws and practices. Article 38 says that the data protection officer shall be involved in all data protection issues within the organization, which means the data protection officer is actually in charge of making sure that all the policies, procedures, to-dos that we've described in the presentation are followed through on. That being said, the data protection officer actually has no statutory power to require a processor or a controller to take any action. So one of the interesting aspects of this role is that the data protection officer really needs to be someone who can lead within the organization, who can get buy-in within the organization, both to be an influential person in the data protection officer's own right, but also to have an organization give the data protection officer the necessary resources to pull all of these actions and activities together. The data protection officer is a creature of Article 37 of the GDPR and then elaborations in Articles 38 and 39. Very helpfully, the Article 29 Working Party, established under the directive, has actually issued some very helpful guidance on the role of the data protection officer and whether or not you actually need a data protection officer. And that guidance was issued at the end of 2016. It is useful to very quickly review whether you need a data protection officer. A data protection officer is mandatory for all public authorities. Brackets, there is a slight carve-out for judicial public authorities. In the public and private sector, a data protection officer is also required where the core activities consist of processing operations, the processing of data, which require regular and systematic monitoring of data subjects on a large scale, or which involve special categories of data, and in this case, very specifically calling out a duty to have a data protection officer if you are processing criminal data. The sort of definitions of systematic monitoring and large scale are not defined in the regulation. There is some really helpful criteria to consider that's set out in the advice of the Article 29 Working Group. But what I really want to point out is that the requirement to have a data protection officer on that sort of language seems to be based around technology companies. It's clear that technology companies systematically monitor data subjects and hold large-scale databases. But this is not the case, and it's important to understand that it's not the case. And some of the examples are given by the Article 29 working group note that hospitals, financial institutions, insurance company, travel agencies, anyone who's processing behavioral data and analytics, and anyone who is involved in telecom services certainly needs to have a data protection officer. So it's not just data providers and those in the sort of tech sector who are required to appoint a data protection officer. If you aren't required to appoint a data protection officer, you can make a voluntary appointment. But here the guidance really is, by all means, appoint someone in your organization on a voluntary basis to help manage these activities. That's a great idea. You might want to think twice about giving that person the title of Data Protection Officer. If you do make a voluntary appointment, you must comply with all the requirements of the GDPR which relate to data protection officers. So if you give the title, you have all the obligations. So if you're not required to appoint a data protection officer, you might want to give that person who has a significant data protection role a different title. As I sort of suggested by my introductory remarks, the data protection officer is the cornerstone of accountability within the organization and is at the heart of the GDPR. So whenever a data subject or a supervisory authority has questions about an organization's data protection roles and responsibilities, it is the data protection officer that they're going to come to, and indeed the identity of the data protection officer is required to be notified to the applicable supervisory authority. It's also important to focus on what the role of the data protection officer is. It is an advisory role, and this means that the data protection officer advises those who are responsible for making decisions within the organization on what he recommends or advises that should or should not be done in a particular circumstance. The data protection officer does not have the power to command an organization to take a particular activity. It is, and the advice is quite strong on this, is that it remains the controller or the processor who is liable for the failure to implement the GDPR and not the DPO. This means, of course, that because the management of the controller or the processor has the fundamental legal liability, that the DPO can be overruled by management. And so the decision and the liability are going together. But this can make the role quite complex, as I mentioned, for the DPO, because he really is, or she is really carrying out this role and managing all these data protection requirements almost by force of personality and confidence that in the organization of the good judgment and expert knowledge of the data protection officer. Similar to many other appointments for European rules, and this will be similar, some of you may be familiar about protections in the employment space about union representation and works council representations. The data protection officer does have statutory protection against unfair dismissal and victimization. So just because the data protection officer is taking or giving unpopular advice, that certainly is not a legitimate reason for termination of the appointment. So that is a very important protection. The other important thing to note is that the data protection officer is subject to all of the confidentiality processes and procedures within the organization. So he does not have a right to speak in his own right, except for the fact that supervisory authorities, as I think Paloma and Ondina have mentioned, have access to the data protection records, which the data protection officer is handling and organizing. As mentioned earlier, it is a complex role. It may be that organizations don't, within their own resources, have the ability to find the right person to undertake the responsibilities, and the regulation is clear that you are able to use an external service provider in connection with your appointment of a data protection officer. So in conclusion, I want to go through a few things of our to-do list with regard to data protection officers. The first thing is review whether the DPO appointment is mandatory or voluntary. And as I mentioned, if it is voluntary, then use a different title than a data protection officer. The advice of the working group is that as you make a decision between mandatory or voluntary, you should document the factors that helped you come to that conclusion. Now, because it is such a complex role, it's really important to consider who's best able to take on that role within the organization. And there are two aspects to this, is that the data protection officer can have different roles, but some of those roles may present a conflict of interest. So for example, the IT director has a wide responsibility for the IT function, but if he is also supposed to be, if you like, monitoring his own compliance with data protection rules, there's a sort of inherent conflict there. And so the advice is that may not be the right person for the role. A very important aspect, and this may be different for US practitioners and UK practitioners than for European practitioners, is that there's no legal privilege associated with the data protection officer's role. And so if you're a lawyer working internally on a number of matters and you also have the data protection officer role, you have a real danger that the privileged environment that you're used to operating in will not apply for any of your data protection duties. So it's quite an interesting question as to whether or not anyone with a legal role should be appointed as a data protection officer. And this may depend jurisdiction by jurisdiction. And finally, just to re-emphasize that the data protection officer is part and parcel of all of the other advice that we've sort of gone through, and the advice that we're going to continue to go through. The data protection officer needs to be integrated in all the decisions made and be at the heart of that process. And with that, I will turn things over to Olivier.
Many thanks, Liz. So now we'll address quickly the issue of the new requirements of the GDPR with the data processing agreements with providers. Well, the key issue here is that very often the data controller, who is the person who decides on the purposes and means of the data processing, is not always the person or entity that actually implements the data processing. And so in that case, the data controller would resort to a data processor. The first point is, as regard the definition of data processor in the GDPR, it is actually unchanged with respect to that in the Data Protection Directive of 1995. And the data processor is defined as the natural or legal person which processes personal data on behalf of the data controller. For example, that would typically be the provider of hosting services for personal data, or the provider of payroll processing services in relation to employee data. So in this respect, for the role of the data processor, the 1995 directive currently imposes limited constraints for data processing agreements, and these constraints are as follows. First of all, the data processing agreement must be in writing. Second, the agreement must provide that data processing service provider should process personal data only in accordance with the instructions of the data controller. And third point is that the data processing agreement must lay out the measures required from the data processor to protect the confidentiality and security of the personal data. With respect to these requirements, which are continued under the GDPR for data processing agreements, the GDPR adds actually some additional requirements for data processing agreements, which are as follows. First of all, the data processing agreement will have to mention that the processor must ensure that its personnel is bound by an obligation of confidentiality, be it of a contractual or statutory nature. Also, the processor shall not engage another sub-processor actually without the prior written authorization from the controller. The additional requirements set forth by the GDPR include also the fact that the data processing agreement should mention that the processor must assist the controller in responding to requests from data subjects in relation to the exercise of their rights, which include, as Laurent mentioned earlier on, the right to access their personal data, the right of rectification, and also, in particular, the new rights of data subjects, including the right to portability or right to erasure. Also, the data processing agreement should mention that the processor must assist the controller with the controller's obligation to ensure the security of the processing, to notify data breaches, be it to the data protection authority or to individuals, also to conduct data privacy assessments and prior consultations of the supervisory authority. The data processing agreement should also mention that the processor must, at the choice of the controller, either delete or return the processed data at the end of the sub-processing. In addition, the data processing agreement must mention that the processor must make available to the controller all information necessary to demonstrate compliance with the GDPR requirements in respect of the data processing agreements. Finally, the processors must contribute to audits of compliance mandated by the controller, and this is a very important point. So now, if we turn on to the practical steps and to-dos in relation to these data processing agreements, these would include the following steps. First of all, obviously, it is necessary for the data controllers to list the agreements that they have with the data processor in respect of the processing of personal data. Then, once these agreements are listed, it's necessary for the data controller to assess the compliance of such agreements with the GDPR requirements for mandatory clauses in the data processing agreements. Also, then, another step will be to undertake a compliance campaign to negotiate with different vendors the updates to the data processing agreements in case they are not compliant. And finally, because compliance is a continuous process, it's necessary not only to ensure that the data processing agreements include the necessary clauses imposed by the GDPR, but also it's necessary for the data controller to implement processes to regularly monitor and audit the performance of the agreements with the processors from a data protection standpoint to ensure the compliance by the data processors with their obligations. And now with this, I'll turn it to John in respect of data breach notification and response plan.
Thanks very much, Olivier. Now, this is an area that's received a lot of attention, and it's a key change in the regulation. So we have a mandatory reporting regime for the first time. And if we have the next slide, we can see how that looks. The controller has to notify the regulatory authorities without undue delay, and if possible within 72 hours of a breach, unless it's unlikely to be risky to individuals. And I think that's going to be read very narrowly. So you have 3 days to respond. It's very tight. And I think it's likely, and the regulation anticipates this, that people will make a phased response. Information will be released as it becomes available. Next, the controller has to notify the individuals if they're affected if the breach has a high risk to their rights and freedoms. So it's a higher standard here, but this is going to be something I think businesses will be more worried about because it will have reputational implications and perhaps could be something that could lead to claims, could lead to litigation. So you have to notify individuals, giving them the same information, but in clear and plain language. But there are 3 key exceptions to this. So if you've put in place appropriate measures such as encryption, or if you've taken effective remedial steps, then you don't have to do this. And I think this will be very attractive for business. Equally, if it's disproportionate to notify and you make a public notice, then again you don't have to notify individuals. But I think because of the public notice, this will be less attractive. And finally, processors must notify controllers of breaches without undue delay. And I think it's important to see this against the backdrop of what else is in the regulation about security. And I won't go through all of these, but there is a lot there. And again, breaches exist by reference to what the obligation should be. Next slide, please. In terms of a practical plan, you start with an audit of your data and review of the security. Next, you review your processing agreements. They should have obligations to pass on information about breaches and assist with the response. It's important to have a data breach response. This used to be best practice. I think it's now mandatory. And identify a data breach response team and ensure they're properly resourced and ready. Consider encryption, data minimization, and data destruction. It reduces the impact of a breach and the amount of data that can be compromised. You must keep a data breach register, and it's important to document the decisions you make about notification, particularly where you decide not to notify. And finally, it's important to review that your insurance has adequate coverage against cyber risks. Jörg, transfers now, please.
Yes, thanks very much. And I'm conscious of time, but of course we want to make sure we present all the topics that we promised to present. The issue of ensuring compliance with cross-border data transfers requirements has good news and bad news. The good news is we still, under GDPR, see the existing system of having great restrictions to transfer data from countries in the EU to countries outside of the EU. So the main principle of the system, how data transfers are restricted in Europe, remains the same under GDPR. And transfers can be enabled at the same time when companies, organizations put in place appropriate safeguards. And you see on the slide here we have listed, obviously there are the well-known adequacy decisions by the European Commission that concern certain countries. So this is kind of like the whitelist, so you can transfer data to these type of countries listed here. So that mechanism of having adequate decisions will be maintained under GDPR, so we may or may not see more countries on that list. Further, companies can still use EU standard contractual clauses to enable data transfers between the EU and countries outside the EU. There are currently developments with regard to these clauses. I want to mention there are, in context of the privacy sheet discussions and the declaration of the ECJ of safe harbor to be invalid, considerations to update, revise the EU standard contractual clauses. The EU, the governments of the different member states have met in Brussels a couple months ago to work on these new versions of the clauses, and we have to see when they will be available. Binding corporate rules can still be used as a tool to enable intergroup data transfers, a very holistic, comprehensive approach to make sure data can flow freely within a global company and organization. Most recently, we saw the adoption of the EU-US Privacy Shield as well as the Swiss-US Privacy Shield frameworks that again enable lawful transfers from the EU or Switzerland to the US only, I should emphasize in that context. Last but not least, I want to mention derogations. They're very similar to the EU Data Protection Directive that we know so far. These derogations are still available to basically justify data transfers. However, in practice, obviously, since there are exemptions, their value is quite limited. And an exception maybe where this plays a role is to establish legal claims. For example, when you think about disclosing of data in context of U.S. litigation, then this derogation may come into play and has a bigger role actually. Otherwise, the derogations are more carefully to be used in practice. There are two new possibilities, ways of enabling data transfers, which are approved code of conduct under GDPR and a certification mechanism. Obviously, that's a very nice thing to have, code of conduct specifically. I think if certain industry sectors, that's the whole idea, give themselves a code of conduct, then this should enable them to transfer data from the EU to third countries. So that could be, from a future perspective, something useful to have. As of today, and this will probably take a lot more time, we do not have these code of conduct available or any kind of certification mechanism. So we have to wait and see how industry develops on these fronts. I'm moving on to the next slide quickly, just to mention that the GDPR also enables now the European Commission to have adequacy decisions that I explained for certain territories only in a third country, or more specifically for certain industry sectors. So that's a great advantage as well. So we'll probably see more activity by the European Commission, also more activity by the data protection authorities to focus on these possibilities to make sure that data transfers are enabled to help business do what they have to do in terms of moving data across countries and borders. At the same time, these adequate decisions, that's a new element in the GDPR, are set up in a way that they can be reviewed or must be reviewed, and they can even be changed or cancelled or suspended if the European Commission feels that a certain country, territory, or even industry sector does not provide for enough protection anymore. And last but not least, we also have a number of new provisions regarding the issue that some of you may be familiar with practice, where you get a request from a non-EU based authority to disclose certain data across borders, and here the Commission felt that this should be captured in a provision that such a request is only enforceable if it's based on international agreements. And so basically no longer should be the direct reach out of non-EU based authorities to private companies to request data of employees or customers or similar. We will luckily get guidelines from the European Data Protection Board that will replace the Article 9 Working Party on these issues, and hopefully get some more guidance on best practice. So what does it mean, talking practical steps? When you look at international data flows, it's just useful as a precondition when you look at your compliance efforts to get an idea how is data flowing within the organization across the different countries, across borders, which entities are getting data, which entities have access in other countries, and so on. And then based on that, consider the appropriate data transfer mechanism. You saw there's a whole range of mechanisms that's available to choose from, and implement that to the extent necessary, or update existing data transfer mechanisms, for example, when we think about the EU model contracts. And of course, we now have some time left, and I hand back over to Jonathan for our Q&A session. Thank you.
Thanks, Jörg. Just before that, of course, we've mentioned 10 topics, but there really needs to be one roadmap to get you to compliance. And I think important points to note are the clock is ticking. The 25th of May 2018 will be here before we know it, particularly if you have to make systematic organizational IT changes. Then we really need to do this quickly. It's important to have a coordinated approach across all of these areas, and I think it needs to have a high level of management buy-in, resourcing, and budget to go with it. And with all of these steps, you will start with a review of what personal data you have, where is it processed, what's the purpose of processing, and what existing consents policies do you have, and you'll go from there. You need to identify a team to do this: operations, legal, marketing, HR, IT, but at all times make sure this is a project that's owned by the appropriate person. I think we have time for a few questions. Undine, would you like to maybe ask the first one?
Yes, we already received one question, I guess, from the audience, and this was really on what impact on companies the GDPR will have that actually only run a US website with no operations in the EU, but the website may have visitors from the EU. That's, I think, a very interesting question. It's practically very relevant because the GDPR has, in fact, a so-called extraterritorial reach, which means it can be applicable to controllers or processors that are based outside of the EU, but only under two conditions, actually. So one condition is that offering of goods or services occurs to data subjects in the EU, or that the behavior of the EU data subject is monitored. So if this US website is only accessible, but there are no factors like, for example, that a certain language is used of an EU member state, or a currency like euro is indicated on the website, or that there is a possibility for EU citizens or EU data subjects to order goods or services. If this is not the case, then GDPR would not be applicable. But if this is different and you are actually targeting EU customers, then even if you are maintaining, even if you have a US website with no presence in the EU, you would be caught under the GDPR. So this was one question that we received, and we encourage you to raise more questions with us. Jonathan, I think there are actually more questions, so if you want to continue.
There are indeed. We've got one in. Paloma, what do you do about existing consents? Do you have to start again, or can you use them?
Yeah. Well, it is possible to use existing consent if they are in line or comply with the requirement established in the GDPR. Then there is no general obligation to automatically refresh the existing consent. However, it's necessary to confirm that we have the adequate documentation of this consent. But we can continue to use the consent if they are in accordance with the requirement of the GDPR.
Okay, thank you, Paloma. Thank you very much. There's another question, and I think this could be a question for you, actually, because it's a question on whether there are any templates or guidelines by data protection authorities on how to implement the information obligation towards the data subjects.
Yeah, it's a very good question indeed, and we also have been confronted with this by a number of our clients. There are currently not really any kind of, at least on EU level, templates how to draft a privacy policy, how to draft a notice, how to make sure the appropriate information is also presented in that plain language, that the GDPR requires, including these icons and so on. But I think what we see is development in different member states where the authorities are working on proposals to make sure that they provide some more guidance to companies how this should look like. And then, in my view, this will be picked up certainly on a more European level by the European Data Protection Board to have something available that companies can rely on. So as of today, we unfortunately do not have anything where we can say, okay, here's a template privacy policy, you can just use it. It will also be, I must be honest to you, difficult to do that because what you have to put in the policy pretty much depends on your data processing activities, types of data you have, the purposes, and of course your business model. So I think what we can see is maybe a frame template document that could be used in the future, but then the content pretty much depends on the organization and the business model. So therefore, I think it's probably a mix of having some kind of framework template available at some point versus that you still need to tailor that to your own organization.
Thanks, Joe. We've got another one in. Laura, might be one for you. Data portability is new, but what do you expect in terms of practicalities? I mean, how long are you going to have to deal with this? What do you do with the data? What can the old controller get rid of the data?
Yes, thanks, Jonathan. Indeed, I mean, with regard to the new right to data portability, you can, it's a different right than the right to be forgotten. So if you have to transfer the data as a former controller to a new controller to this subject, you don't need to delete the data. In addition, as a new controller, if you get the data from the former controller, that doesn't mean you need to keep all data. Actually, you only need to keep the data which are relevant for the processing you're going to do. So if you receive a vast amount of data, you're not supposed to keep the data which are not used for the processing that you intend to do. So that is probably the way it works. So in terms of erasing the data, it's really a new right which is different from the right from the right to be forgotten.
Thank you.
Okay, thank you very much. Well, this is concerning data protection impact assessments. Giuseppe, during your presentation, you also mentioned that there's going to be a positive and a negative list, a white list and a blacklist, so to speak, when or when not to conduct a data protection impact assessment. So is there any guidance already issued on this topic by data protection authorities?
Yes, thanks for the question, Undine. Actually, on the basis of the recent monitoring of the websites of the various domestic supervisory authorities, the only domestic authority which has already issued its guidance on that is the Belgian supervisory authority. The other domestic regulators have been quite lazy on this point so far. On the basis of the guidance we have seen of the Belgian authority, we have 12 cases which require the data protection impact assessment, and we are mentioning among others the processing of financial, biometric or genetic data, financial data which are used for purposes different from the ones for which those have been collected, and other various cases. We have 7 cases which expressly do not require a privacy impact assessment, and we are referring to data processing for management of personnel, payroll purposes, or registration of visitors for access control purposes, and similar. In the next few, hopefully, weeks, we should see additional guidance from the other authorities, and then those lists will have to be submitted to the committee for consistency purposes, because otherwise we will end up again in having different requirements depending on the authority which has issued the positive or negative list. So we will see what will happen, and hopefully by the end of May, when the regulation will enter into force, we should already have in place some clear guidance issued by the various authorities.
Thank you very much, Giuseppe. I think we now have to come to an end, but we will answer any outstanding questions on an individual basis. Let me just give you a brief sneak preview, so to speak. Our next webinar in this series is already scheduled for Wednesday next week, same time, and it is on the topic of how to develop a GDPR compliance program. And we would be very happy to welcome you again. Thank you very much for your attention.
Ladies and gentlemen, handouts of today's presentation will be emailed to you by Jones Day. Thank you again for our presenters for presenting today, and a special thank you to our attendants for joining us. If you meet all of the criteria to receive CLE credit, you will receive an email within 24 hours. If you do not receive an email, please contact Beacon Live. This concludes today's program.